great number of slides for everybody to refer to after the event. We're going to take a slightly different format in terms of we haven't got 4 PowerPoints, we've just got 1 PowerPoint. And we're going to have, if you don't mind, I'll sit down. We're going to have a conversation for expatriates who have been in Vietnam for, sometimes I worry, sometimes 25 years, some of us, 27, 25. And we're going to give you some insights into Vietnam. So I've worked in Hong Kong, Singapore, UK, my original base. I think Mark's worked in Australia, similar places. So we've got a sort of international experience. So this is not a critique of Vietnam. So please do not take it as a, us unloading on Vietnam issues that we've come across in our careers. Delays are perennial throughout the globe. The global arbitration review cites delay as the leading cause of disputes globally. Being from the UK, you'll know, if you're a football fan, you'll know Wembley Stadium. That was late, 2 years, so we got it wrong there. The Channel Tunnel was like 3 years late. Another one is Crossrail is 3 years late and 2 billion over budget. So delays happen everywhere. So please do not take this as a critique of Vietnam. We're going to maybe give you some insights into things that we think go wrong sometimes on projects. So I'll just hand the mic to each of my panelists. Maybe they can introduce themselves. I started my career as a quantity surveyor. I'm now an expert witness. I do contract administration, and I've worked on public and private sector projects. And I think that's an important distinction, which will come out later when we talk about owner issues. So if Mark, could you introduce yourself?
Hello, can you hear me? Okay, good. I'm Mark Olive. I've been in Vietnam for the last 16 years. I currently run my own business, which is expert witness, arbitrations, claims, commercial management, contract advice, that type of thing. I've known David a good 25 years, and we did work together in the past. My background, about half of it in the past has been as a commercial manager with contractors in Vietnam, Hong Kong, and parts of Asia. And the second half, I was the general director of David Langdon Chia here in Vietnam and Cambodia. And I'll pass you over to Colin.
Thanks, Mark. I'm Colin Johnston. I'm currently director of BK Asia Pacific here in Vietnam. I'm a professional quantity surveyor. I've been here for 26 years with BK Asia Pacific, and we do a lot of assistance on claims and disputes. We have other offices in the region that do the actual expert work, but I stick to the quantity surveying side of it. So that's the quantum part. So thank you.
Hello, my name is Paul Menzies. I've been here in Vietnam for 4.5 years. I run my own company here, specializing in engineering, surveying, and geospatial technology. My background in the UK was from civil engineering, so I've got quite a decent amount of construction experience. I'm not so much on the law side. I do a lot more project management, so actually on the ground, getting things done. So where you might see a lot more on the quantum side from these guys, I'm here to try and be the more practical side. So thank you.
Okay, thank you, panelists. Just got a technical issue already. Excuse me, IT, I cannot move the slide. There you go. So our very short presentation today, because I think we've all probably had enough PowerPoints, maybe this afternoon a bit more conversational. So five parts, and the Q&A will be 10 minutes. But feel free to interject at any time, because we're just talking amongst ourselves, so interjections will be good. We're looking at main causes. We'll keep that brief because we've had a lot of causes today, but maybe expat insight. Best practice EOT, what we do as quantity surveyors or arbitrators or experts, what we look for in an EOT claim to either approve it or disapprove it or look for more information, and quantum issues, mitigation measures, and Q&A. So we've just put this slide up, and we know we're repeating what's been said today, We've broken it down into the categories of owner, contractor, design, and the VN market. So at the top of this conversation, I'd like to note that state projects and private projects differ considerably. Under a state project, of course, we use FIDIC, and probably we're using MDB, Harmonized Edition 2010. And under private projects, we're normally using FIDIC Redbook, which are very similar books, as you all know. The former is more adapted for use by banks, but it's basically Redbook. All state projects tend to be remeasured. And in that very simple issue creates a few problems along the way for number one, payment, and then we get delay. Payment remeasurement is based on shop drawings. Shop drawings often delay the payment process, and therefore we have a knock-on effect through the whole payment sequence. Private projects tend to be lump sum, so we don't have that remeasurement issue. Basically, it's between the employer and the contractor, and often they will appoint a project manager or a QS to arbiter on an EOT claim. Under public sector projects, I'm talking class 1 projects, roads, bridges, infrastructure, we have the engineer who sits between the employer and the contractor and is meant to be fair, impartial, depending on which FIDIC you're using. 2017 has a slightly different approach. Oftentimes we find the engineer is overruled by the employer. That is not the real essence of FIDIC. So apologies to anybody in the audience, but we do find employers overruling the engineer considerably, and that literally does delay the process. Furthermore, on state projects, we have a lot more entities involved. We have Ministry of Transport, for example. I'm working on a road project. I won't mention the name, but we have various parties involved outside the contract, outside the contractor, outside the employer, outside the engineer. We have, as we've mentioned this morning, MOT, Ministry of Transport, Ministry of Construction. Then we have other people like the State Audit Committee. All these entities can have an influence on the project progress. Now, oftentimes the contractor is an international contractor and doesn't really know the law inside out, as well as people in the audience here, leading to delays. So that's an issue I find. If I can ask Mark if he's got any issues on owner situation.
Yes, I have. I've got issue with microphone. Okay, now, thank you. Let me just ask a question. How many people here are contractors? Could you put your hands up? Okay, quite a small portion, which is because really a lot of the issues with delay is the lack of claims preparation by contractors. That really doesn't help in them pushing forward for the entitlements. But concerning specifically owner delays, a lot of that delay is actually happening before the contract's formulated between owner and contractor. But a lot of those delays, it tends to get reciprocated through into the contract for various reasons, largely because certain delays such as approvals or design, if it's a traditional building, that type of thing. A lot of that gets delayed, as we all know, working on the client side and the employer side. But that tends to get pushed into squeezing the contractor's bids. I've been in a lot of cases where a tender is bid on, say, 36 months or 24 months or whatever, but the employer wishes to shorten it. I think contractors are getting a bit more sense that if the program is shortened, then they have an entitlement to, or they have reason to consider that risk and start to build in various damages associated with that tightening of time. But still, there's a lack of understanding of that in both parties. So that's a big issue. During the construction period, I think the contractors, we all know what the employer delays are, whether it's variations, whether it's late payments, that sort of thing. So I think everyone has a sense of knowing that this could cause delay to a project. The problem tends to arise in that the contractor doesn't manage it properly. This is the problem. I think I had a meeting this morning actually with one of the major contractors, and everybody seems to understand the risks at the bidding stage and what to do. But once it gets onto the site, that's all forgotten. All everyone cares about is getting the job done and doing it well. And to be honest, most of the construction side of it gets done pretty well. But it's really sort of like managing these risks when they occur. For example, late payment of ICEs, it's a big problem here in all sectors. And one of the things we discussed this morning, a lot of contract, I mean, it's a major default on a project. You know, it's a breach of contract, a fundamental breach, and contractors have an, you know, they have an entitlement to suspend or terminate. Often they don't want to because they don't want to upset the clients. But what they don't do is put in the necessary notices, claim the unpaid interest. There's a lot of things they don't do, even if they commercially wish to continue on the job. And that's the fundamental problem with all these employer risks is actually managing them, making sure everything's recorded, making sure notices, etc., put in at the right times, and making sure you're claiming the money. So that's really my rather long-winded thoughts on that. So I'll pass the microphone over back to David. Colin.
So we're talking about, we've moved on from contract.
I think you can, yeah, I think you can just pick any ones you like, really. I mean, we've gone through owner. For me, it's more about interventions, it's approvals, multiple bodies, multiple stakeholders. It's complicated for us foreigners. I'm pretty sure it's transparent to the legalese in the room, but for us or contractors, foreign contractors, it's difficult.
Yep.
But I know, Colin, you work more on private sector projects.
Indeed, and I think that, as you say, that the challenges are quite similar in a lot of cases, but we're finding on the contractor side that sometimes they're their own worst enemies in not having the right number of staff for a project, not considering a proper resource-based program at the beginning of the project to understand what they need when they need it. Also, not getting procurement sorted out in reasonable time, particularly in the current situation we've got with COVID and wars and so forth. The procurement, the supply chain is massively extended, and a lot of contractors are really not grasping how significant that is at the moment. And we've got a job just now where the lead time on some of the main equipment is over a year. And now, obviously, that has a massive impact on how the project is managed. And clients are not going to take on that risk. That's a contractor risk on their side. Sorry, the other one I just want to touch on it is also just a late appointment of subcontractors for me is critical. Again, understanding when you need someone on board and understanding that whole procurement process to get that subcontractor on. There is in FIDIC owners entitlement or the employer's entitlement to vet and approve subcontractors. And if you're leaving it to the last minute, then that approval process can fundamentally delay the project as well. So just consider that as well from a contractor point of view.
Paul, got anything to add, or you want to save yourself for later?
So again, more from a practical side, one of the key things that we found going into market in Vietnam, we're quite a new company, is that often the owners, if they're quite a new company, you know, there's a lot of new developers out there, for instance, they don't necessarily have the skill in managing what their ambition is, right? They want to do very large projects, you know, they manage to raise the funding, but then they're not putting the expertise, or they're not getting the expertise in. So for instance, they're not getting competent project managers, for instance, for representing their interests. They're not considering how important contracts are. A lot of the time, they've had some easy money, frankly. And now they want to build something. And of course, you know, it makes sense you want to build something, but the challenge that we've seen with them is that often they don't know what they want. They want a building, that's it, very generic. They're not very clear on their tendering. So again, we want a building. Builders a building, they're not being very clear about what they want. And then once the design process is starting, that contractor, which was the cheapest that they picked, is now coming back and saying, well, this isn't the scope. You know, we've had a lot of ambiguity in it. So there's a big mismatch between what the owner often wants. For the big projects, it's not so bad, but for the, for the big long-term developers, it's not too bad, but for the new ones, it's a big challenge about setting expectations and then scope of the work. Maybe I rambled a bit on that one, but
it's okay. So I think just to sort of, I think we've exhausted reasons for delay in Vietnam during the morning, but I just want to look at the last column one more time, the Vietnam market. These are the issues that are probably specific to Vietnam as opposed to working internationally. So approvals and permits is complicated for us. Sometimes the PMU needs to refer to other bodies like the State Audit Committee and maybe cannot make decisions on the spot, on the ground. And that just leads to late payment and then interest on payment. And then we go to notice of dissatisfaction. Then we go to arbitration. I'm working on 2 arbitrations at the moment over late payment. Site encumbrances, we know there's lots of issues with clearing land and compensation. That's a very common issue in Vietnam, also in other countries, but especially in Vietnam because it takes a lot longer because there's more parties involved. Labor is normally migrant. It moves between provinces. Sometimes it's not as skilled as it could be. Therefore, productivity on the project is low. And then moving on to some legal issues, I see now more dispute boards, but it's only just coming through, whereas dispute boards are very common in, say, Singapore, Hong Kong, other countries. So I think that wraps up the reasons for delay. That list is nothing new. That list has been spoken about this morning. So let's move on to best practice. Having identified that delay is a big problem, so then what happens? The contractor gets into difficulty commercially. He needs to put an extension of time to protect himself from delay damages, which are capped under the law at 12%, is my understanding. But the contractor's claims tend to be pretty weak in my experience. So I'm going to basically, if I'm looking at a claim as a contract administrator, or if I'm looking at a claim as a QS or an arbitrator, I'm looking at 5 steps. So these are the 5 steps. Has the baseline been established? Can we compare, analyze the as-built? We had a discussion this morning on the different delay techniques. We don't go into that here. Can we identify cause and effect? It's very, very simply. Oftentimes that does not happen. Are the contractual entitlements met under FIDIC? For example, the notices, is there mitigation? Then we review the evidences and then we prepare the quantum. If I don't see those 6 steps joined up, there's something wrong with the claim and it's not going to go very far. So, and unfortunately, the situation becomes worse. The contractor can't get a decision. He can't get an EOT. And then we end up in the dispute spiral where we end up in arbitration. So I don't know if anybody from the panel wants to talk about maybe notices or mitigation or.
Okay, thank you. I won't save myself till later. I don't know what we're doing later. But anyway, I suppose the most important thing, it's not mentioned on there, the most important thing about claims is that you need to put the notices in. Certainly on FIDIC contracts, it's a condition precedent to put the notices in at the right time when there's an awareness of the delay. If a contractor is generally late in submission of the claims, at least under FIDIC 1999, it does change in 2017, the new FIDICs are coming out. But if the time of the submission of the claims isn't in accordance with the contract, there can be a sympathetic view on that up to a point. But if the notices aren't issued, then the contractor has a real problem. So for the 3 or 4 contractors who put their hands up earlier, out of the 100 of you, pay attention to that and tell all your friends as well. But that's the most fundamental point. It's often the case when I'm working with contractors that the notices aren't in, so we'll find another solution to it. And there can be ways around it, minutes of meetings, emails, but you got to consider the capacity of who sent it, who they've sent it to, all that type of thing. You know, in contracts, there are procedures that define what a notice is. what I'm really saying is a notice doesn't have to be perfect. It can get the clauses of the contracts wrong. I don't think that's an issue in itself, but it needs, something needs to be issued that's at least resembling a notice.
Yeah.
It just makes everyone's life a lot easier.
Yeah, I think part of it also is a cultural issue. And I think this, when we start a project, we will always sit with the contractors, contract management, and we will emphasize that the contract is there to help everybody. It's not there to be contractual. It's there for everyone to follow. And if there's something in the contract that says you shall do it. Nobody's going to be offended by you submitting a notice. And I think that part of the cultural thing that I find here is people are afraid. They don't want to upset the client. They don't want to upset the team. But if you don't do it, you lose entitlement. So I think we will always sit with our project team and we work as a team to get the project completed. So the emphasis is on communication and working together. And I think that can't be emphasized enough at the beginning of a project.
Yeah, I mean, I totally agree with that. One of the things I say to a contractor is, and it's true, the point of a notice is to benefit both parties. It's so they know what's happening on the job, so something can be done about it. And that's one of the things when you're looking at a case as well. What you want to be doing is, even if the notice isn't in, there does come a point in time when both parties are aware there's a delay and that type of thing, and that has to be considered as well.
Yeah, and also I think Robert will deal with this later on with NEC, I think, but the FIDIC is now starting to bring in some of the similar terminology, I think. But in terms of early warnings and early notices, if you know that something is going to happen in the future, that you're expecting a delay to come, don't wait till it becomes a delay. Tell the client that there's going to be a problem, and then we can mitigate that earlier if possible. I think that's a big positive.
Just adding to what Mark and Colin was saying, from a practical point of view, being in the field, I think it's really important that construction companies, contractors, they are setting very clear SOPs, and they're doing a lot of internal training to really make sure that their engineers, their PMs are confident. You've got a lot of team leaders on construction projects. They need to understand the importance of documenting the works that are going on, making sure things are signed if they need to be signed. So just from the very start, like Colin was saying, making sure you've got very, very clear procedures in place. There's many times that, there's been confusion. Maybe we've been dealing with a main contractor. There's a lot of confusion about how things need to be documented. They're not setting very clear what they expect the subcontractors to be doing in terms of documentation. And really, everyone needs to be working on the same page. Yeah.
I'd just like to put a slightly different slant on the EOT claim. Even if you've got the best, the most 100% entitled to the claim for EOT, if it's not prepared properly, it will fail. And that doesn't help anybody really, because the contractor is in a situation where he's losing money. He is in delay. It may not be his fault, but he cannot demonstrate it or prove it or back it up. And the engineer can only work on the information he's given. He can only make a determination based on the information he's got in front of him. He may say, yeah, you're entitled to it, but you haven't proved it. You haven't shown it. So that doesn't help anybody, because then the contractor falls into a greater delay, loses more money, and the project just goes into a spiral. So there's a responsibility on contractors to put in professional, well-prepared claims that may still not be accepted, but they should be professionally prepared using some guidelines like this. So that's something we see a lot. I see a lot of claims, EOT claims that I see after the event as an expert, and I can't do anything because the records aren't there, the notices aren't there. There's just no evidence for me to. So I have to say, sorry, no evidence, can't agree it. And that's a very easy defense for employers. They will often say that the evidence is not there. So records for contractors in the room. And that's the only way to ensure success. The engineer must be impartial, must be fair. He has a duty to review the claim. He can't just dismiss it because he's protecting his client. Under FIDIC, that is not the way the contract is established. Admittedly here, the employer may put pressure on the engineer. That happens probably in other countries as well, but that's we've seen that happening in Vietnam.
Sorry. One thing to just add to that. One of the big things that really surprised me being quite new to Vietnam was pretty much there seems to be a culture with a lot of contractors where, with the exception of some very high level people where they've got a lot of industry experience, anyone from mid-level lower, they tend to have this a very generalized stereotype, I admit, but they tend to not see the importance of strong law, right? Strong contracts. You know, quite a few times I've been told directly, oh, well, the law isn't very good here, you know. And yes, there are things that need to be improved on that, but it shouldn't stop you from documenting things. Yeah, documenting and going to the court, going to a court or arbitration is always a last resort, right? But if you're going into your client and saying, right, we've got this and it's very well documented and it's been done at every level, it's really important, because at that point, it's an internal discussion, it's an internal negotiation between you and the client, and it's much easier to resolve it. When we see a lot of the newly graduated engineers, they're coming and saying, oh, the court, you're never going to win, so why bother? You know, why bother to document stuff? And it's a very bad approach that we find.
Okay, thanks, Paul. Okay, we'll move on to the third topic, which is quantum, which is what we three are as being quantity surveyors. So this is hopefully our stronger topic. Delay is for the delay experts, which we heard from this morning. So when I receive a claim, it's normally based on three heads really: indirect costs, profit, and overhead. Yeah. So even if you've properly demonstrated your delay, you've used critical path, you've used one of the methods that we've heard about this morning, it's all perfectly evidenced. Now the next stage is to get the quantum properly evidenced. Again, this is where it fails quite often with contractors. They haven't got the records, they haven't got the labor contracts, they haven't got the rental agreements. Sometimes it's like an information dump onto the engineer or indeed the expert later on in the process. So very often a contractor cannot actually prepare his costs well. So we look for the project team costs, the salaries, the bonuses, the flights home, all that is claimable, but it needs to be aligned to the delay period. Was that person there during that delay period? What was he doing? Was he productive, or was he just being kept there for whatever reason? So these are all the evidences that the engineer will investigate, and then later on the expert. Very oftentimes a contractor will just keep people on site and not being busy and expect to be paid. So equipment rental costs, plant costs, accommodation, demobilization costs, these are all records that we need contemporaneously. So record keeping again. So the catchword here is, or the key word is, compensation is for reasonable actual costs incurred during the delay. Okay, actual costs incurred. Maybe somebody else would like to talk about profit or overheads.
Oh, thanks. Not quite sure what to say about the profit at the moment, but let me just going back to the whole fundamental issue on the claim thing. What we're talking about here is prolongation costs. So this is costs in relation to time you get awarded, your extension of time. There are other standalone cost claims that you should be preparing as well. We know about variations. You don't have to notify those. That's something that should be going through the machinery of the project. You need to be aware of unforeseen conditions, those types of things, which aren't instructed, and they're not prolongation costs. Keep those as a separate account. The important thing about the prolongation costs is that the money follows the time. What I see a lot in claims is the contractors focusing particularly on the money, but not the time. But you've got to get the time before you can then get the money. That's the most important thing to remember. In terms of overheads and profits, generally the contractor is entitled to the overheads. Profits is a different issue. I mean, there are some cases under FIDIC that profits can be considered, but in general, in most cases, overheads are considered, but not profits. It's generally the costs. And as David said, they've got to be proved. The formulas, there's all sorts of formulas for overhead calculation, and on paper they look really complicated, but they're not. I mean, basically what it is you've got a percentage of overhead on which you're applying to your prolongation costs, your site overhead. Yeah. So you're applying whatever it is, 3-4% to that. And the point is you want to be applying that same amount of overhead, if you can, to the duration of the extension of time. So it's a fairly simple maths things to solve. I think that's all I need to say on that at the moment. I think that's all I need to say on that at the moment.
Interesting point on the formulas. I've read recently in a project I'm looking at, is the opposing party said Hudson's is not applicable because it's not in the contract and it's not recognized under Vietnam law. So my question to any lawyers in the audience, maybe later, is, has anyone got any views on that? Because we all know in the SCL, in the protocol, so, the formulas are all noted, but it's been rebutted on my project for not being in the contract. So that was an interesting one. I didn't quite know how to deal with that. I've got to ponder that over the weekend. So Mark's got a view. I'm happy to hear Mark's view.
Thanks very much. Just because the contract's silent on something doesn't mean you can't claim it. It may end up having to be solved in the jurisdiction of a court, but because this is a common employer game, is to say the contract doesn't consider an EOT for this reason or that reason. There's no reason still not to claim it and try and claim it and try and negotiate it through. But just because the contract is silent, it doesn't mean it's out of bounds.
Anything, Colin?
Just to touch on the lost opportunity costs, that's obviously something that everybody wants to claim, because if we had finished this job on time, we would have moved on to another project. Almost impossible to get that validated unless you can prove that you had to decline a tender, or the equipment that you were going to move to the next job was actually going to be used on that project. It's nigh on impossible, in my view.
It's very special when one person does it, and then maybe it takes it. Generally speaking, it's mission impossible.
Yeah. Maybe a final point, just going back to my point on the formula. That's an example, and of where sometimes the law is used as a sword, but also a shield. So I don't want to be controversial, but I've seen it used to rebut contractors' claims, and some obviously these international contractors don't know the law as well as they should, so sometimes they're at fault. Why did they sign a contract that they haven't fully appraised the risk? But that happens quite a lot, but they should employ local lawyers like people in the room to mitigate those risks. They should know what they're going into. They should not know every law, decree, guideline, ordinance, decision. They shouldn't be necessarily aware of everything, but they should be aware that those risks are real, and their claim for EOT and quantum is governed by the law. Whatever it says in FIDIC, whatever they signed in the PCC, particular conditions, sorry, if it doesn't comply with the law, it won't go very far and the claim will fail. And then I keep using the word dispute spiral, but that's normally what happens. Anything else on that slide? No. Yeah. Okay, so this slide really, I can go through it quite quickly because it's just one key point really. This is FIDIC effectively, but I haven't put any FIDIC clause references here. But what is the contractor entitled to? Is he entitled to just the cost, the time and the profit, or just cost only? So it's very, very clear classification. Is the event a employer delay? Is it a contractor delay, or is it a neutral delay? So normally when it's an employer delay, and that means the employer and his engineer and his design consultants and his permits and his licenses and his approvals. If it's an employer delay, the contractor gets everything. He gets cost, time, and profit. If it's on the far right, a neutral event, like for example, weather, unforeseen conditions, force majeure, global issues, it's neutral, nothing to do with the project, nothing to do with Vietnam, he will only receive cost and no profit. So this is effectively what FIDIC says. So this is an interesting point. Profit, not this doesn't mean lost profit, it just means profit on the rates, yeah. So we're coming to the last section, so I'm just going to do a quick time check. Okay, we've got 10 minutes, so we're on schedule. Not like the World Cup where we're going into injury time for 15 minutes. So mitigation measures. So mitigation, I heard it mentioned earlier, and it's an interesting concept. Every contract, construction contract or any contract expects the aggrieved party or the hindered party to mitigate that loss. Okay, he cannot let that loss build up, accrue, and then present the other party with a check. That doesn't obviously make sense at all. It's not equitable. So under construction contracts, we must see the contractor mitigate. But what does that mean? Does he need to demobilize people off site? Does he need to reduce costs? Does he need to reduce cranes? What does he do to mitigate? It's his risk as well if he does demobilize. So I'd like to ask Mark or Colin. Anyone want it?
I mean, to distinguish, I tend acceleration is something where the contractor's effectively being paid by the employer to recover an extension of time or something. Mitigation is where the contractor's in delay and he's trying to pull back the time for his own purposes. Mitigation can also be split into two areas. I mean, you can use best endeavors, which isn't spending costs. And if if a contractor's got into a delay and he's fighting the extension of time, he hasn't been awarded it yet, he still has an obligation to use best endeavors, which means you don't spend, the contractor doesn't spend extra money, but he does what he can to pull back the program to recover some time. If the delay is the contractor's fault, then if mitigation is spending extra money, that's how I tend to look at it. I see a lot of claims where the acceleration is sort of thrown in all willy-nilly with an extension of time claim, and that sort of thing is very hard, even on very large projects. So I'm not just talking about Vietnam. All over the world, you'll see these claims of EOT and acceleration and all this type of thing, and they're a real mess actually, because I mean, the logic is that you're accelerating to pull back an awarded EOT at the end of the day. Things get confusing throughout the process.
Not so much a view on mitigation as such. I think there are obviously measures that contractors can take to either help the employer, whether they're instructed to or otherwise, to make the program, to match the program. It's obviously in everyone's best interest to meet the time for completion. We've had projects where materials have been air freighted in, for example, instead of shipped in. There's been discussions between the parties about who's going to pay for that, just to make sure that it's done on time. Whether you're going to do additional shifts on site to catch up a program, that might be something that's in there to be either paid for or not, depending on who's going to admit liability or fault for that. And then additionally, there might be resequencing of the works just to make things more efficient on site. I think that's something that can be considered.
Thank you.
Just a piece of advice for all engineers and employers. Don't issue letters to a contractor saying speed up the works, increase resources, this sort of stuff, because basically that's almost a carte blanche instruction to accelerate. So be very careful of that. I mean, my advice really is just don't do it.
No harm in reminding them what the time for completion is.
Thank you. So that was a quick run through the 4 topics, our insights. Hopefully we haven't said anything too controversial. Feel free, please, to ask us any questions, either as a panel, one at the back. Miss Nhi, my former colleague. Please make it nice. Our former colleague. Not too difficult, please, Miss Nhi.
Hello, good afternoon, David, Mark, Colin, on my mentor. I'm Nhi from VNQS. So this is very interesting part where I really want to ask you one question regarding to David's slide. You are showing us for FIDIC, the delay is divided into 3 parts. One is from employer delay, which the contractor can entitle for time, cost, and profit. And contractor delay cost only, and share neutral delay like authority, blah, blah, blah. So we would entitle for time and cost. So my question is, should we as a QS consultant to prepare the particular condition to remove the profit in the delay of employer part and remove the cost in the neutral delay? Should we do it, and what is benefit or what is the causes?
Thank you, Ms. Nhi. Very, very good question, actually. I'll give my very quick answer and then pass on. I was always told that we shouldn't, as QSs, be playing with the particular conditions, and that's for the lawyers in the room. But sometimes we would have a commercial view. My view on particular conditions is keep them as simple as possible. Don't change too much. But yes, Ms. Nhi, you would strike out profit against those items which were neutral. But actually, FIDIC says that anyway, so you don't really have to do too much amendment. But as a QS, I think maybe we keep our amendments quite short and leave it to the lawyers.
I agree. Just going on the principles of particular conditions of contract, don't change too much. I mean, there are some fundamental aspects of FIDIC 99 that probably are sensible to change, such as the approx quants to firm quantities. But really, at the end of the day, the more you try and change it, the more you try and change the essence of FIDIC, you're going against the golden principles. If you look at the FIDIC documents, you've got the 5 golden principles, and a lot of those relate to trying to maintain the fundamentals of the contract. So, you know, you shouldn't take away the engineer's powers and stuff like this, which does happen a lot here. And, you know, I think take out things that then keep the contract silent, like certain event changes for extension of time. You see a lot of these sort of things happening, and they don't, because they actually do go against the grain of what the principle of a contract is.
Thank you. I'm aware we're running out of time. Anybody going to tell us to stop? Oh, Mr. Long. Why my former colleagues always having a go? Okay, this is yours.
Sorry, but this one is not for you or Mark. Actually, I have a question for Colin, because you raise a very interesting term about loss of opportunities. As I understand that, I think indirect loss to the employer or contractor is not claimable, or I mean, it's not qualified as for indemnity under the FIDIC contract. So is that loss of opportunities considered indirect loss or direct loss? Indirect. Yeah. So is that claimable?
Yeah. You would. There you go. Yeah. Yeah, there you
go. Could you repeat the question very quickly?
No, that's
okay. I'll talk to you afterwards. Sorry, anybody else? I think it's end of time. So we'll wrap it up there, unless anyone's got a really quick burning question. Yeah, one more, yeah.
Thank you for your sharing. I had a quick question regarding the indirect costs and the overhead.
Yep.
So my question is that I'm working for an interior contractor, TTT, and we have the costing system to measure the time checking that we have for the project. So we base on the activity-based costing system.
Yep.
So when we claim for the EOT, is that possible that we can use our costing system to claim for the overhead?
Perfect. Actually, I've asked for that exact system on a claim I'm dealing with as an expert, saying, where's your contemporaneous in-house costing system? Because that cannot be created later. That's very clear that it's contemporaneous and it's a good record, yeah. But obviously, it needs to be readable format for another company or the expert or the tribunal. But yeah, a software system is a good way to show your costs, yeah.
Yeah, we experienced that, but
Yeah,
actually it's very difficult for the investor, for the project owner to accept our
Okay,
model.
well, it may dig a bit deeper, but that's a good starting point for sure.
Okay.
Thank you, yeah.
Okay, thanks.
So I think we'll close it there because we're running into the next session. Appreciate everybody's comments and questions and hope it was informative. And have a good afternoon, everybody. Thank you.